Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey there, everybody. Welcome to another episode of our special series from the Federal Newswire's Lunch Hour on the REINS Act, REINS Act in Focus. I'm Andrew Langer. Joining me right now is Ilya Shapiro, author and director of Constitutional Studies, Center for Constitutional Studies at the Manhattan Institute. Ilya, you're going to give me your title here. I apologize for butchering it. But why don't you give us that? And
as long as you mention my new book, Lawless, The Miseducation of America's Elites.
Love it. Lawless, The Miseducation of America's Elites, wherever fine books are sold. Also the author of the great book on the politicization of the Supreme Court. In fact, Ilya, let's start there. How does the REINS Act... Supreme disorder. Yes. How does the REINS Act fit into trying to undo the idea of the politicization of the Supreme Court? Because I think there's a direct relationship there.
Yeah, I mean, we have a warping of our separation of powers because for too long, Congress has abdicated its lawmaking responsibility. It's punted to the executive branch where most of the laws are made by which we live our daily lives. That is, the amount of legislation Congress passes any given year pales compared to the amount of regulation coming out of executive branch agencies, the administrative state. And of course, executive branch agencies can't be unelected, the bureaucrats, and they can only be sued. And so the Supreme Court ends up deciding all of these disputes. When somebody is harmed, or a small business or an individual is harmed, they go to their congressman and they say, why did you vote for this thing that's hurting me? And the congressman says, no, I voted for the Truth, Beauty, and Goodness Act of 2025. Your beef is with the deputy undersecretary of such and such. Go sue them. And again, all of that litigation ends up in the court. So what the REINS Act does is it requires Congress to approve any major regulation, major defined as worth more than $100 million or significant geographic impact.
Yeah. So I mean, here's the thing, right? Because I'm trying to make the case for Democrats to sort of understand why this is important. I mean, obviously, in the wake of Loper Bright last year, I was surprised at the number of folks who wanted to push. Loper Bright shifted power back into Congress to engage in some responsibility. I was shocked at how many folks wanted to push that power back into the executive branch. But if you're concerned about an administration run amok and you're a progressive, this is one way for you to take back that power, isn't it?
Right. If you're concerned about whether Doge or whatever your political enemies might do with the bureaucracy, or if you're concerned about the courts having been taken over by the right, you want the decision-making to be in Congress, and you want political accountability. So that's the argument. After Loper Bright, courts no longer defer to agency interpretations. So I think the left, or any progressive, would want Congress to be approving these things rather than judges or Doge or other unelected officials.
Right. I mean, and that's just it. Now, this has been a long time coming. We've been talking about this for years. I don't know if you have any perspective on the journey that the REINS Act has taken, but it has taken quite a journey over time. Talk a little bit about the genesis here, the work that you do on constitutional studies, and how this fits into all of that. The changeover over the last decade and a half on the separation of powers issue.
Yeah. The reason why in the first Trump administration, the overarching connection between his three Supreme Court appointees, Gorsuch, Kavanaugh, and Barrett, is they all made a name for themselves pushing back on the administrative state, checking the bureaucracy. The REINS Act was first introduced, I think it was about 10 years ago, something like that, more than that, 15 years ago, during the heyday of the Tea Party.
Right.
And it's been introduced in every Congress since. Has passed several houses, several times the House has passed it, but the Senate has never taken it up because, of course, in the Senate, to do anything, you need to survive a filibuster, which is which is 60 votes. The current incarnation adds a few things. For example, individuals can argue in court that they wouldn't have known that their actions violate federal law. So, people get caught up in all sorts of regulations all the time, and they get fined, even occasionally sent to prison. And they say, well, we can't make heads or tails of it. And so this adds kind of a culpability requirement, what lawyers call mens rea.
Oh, yes.
They have to have known that their actions violate federal law. It gives people a right to sue, so they can stop the enforcement of a rule if an agency implements it without congressional approval. And it applies it not just to regulations, but also to guidance, because of course, in the last 10, 15 years, we've seen, Obama called it pen and phone governance, but agencies, without even promulgating regulations, they issue guidance.
Right.
And regulated industries know that guidance, they'll follow it, because that's their regulator telling them what a best practice is. And so this new version of the REINS Act would be applied to such guidance for the first time as well.
Yeah, we had Wayne Cruz on earlier on in this series, and this is the kind of things that Wayne calls regulatory dark matter, isn't it?
That's exactly it. All this stuff going on that is not published in the Federal Register.
Right. Something, let's talk a little bit about this, because we've talked about the issue of the definition of major rules having changed, and the previous administration coming in and changing the way we assess the costs and benefits. There's a fundamental question that's being asked by some in our limited government movement about the administrative state and the idea of this Administrative Procedure Act. Where are your thoughts on this? I take great comfort in the APA because it affords the opportunity for the public to get involved. Others have some real questions about it. Where do you fall in all this as to the importance of the Administrative Procedure Act?
This is the APA is the rules of the administrative state.
Yeah.
And I think you do need some sort of rules, and we can argue about certain things might need to be changed or not, but you can't just not have this sort of rule book. It spells out what hoops agencies need to go through, the notice and comment rulemaking, all of these things that, we have Supreme Court decisions that flesh this stuff out. But the APA in a modern administrative state is really necessary so that the process is regularized, and people know that if they do have a problem, what they need to do to vindicate their rights.
Right. Is there a danger if we go down this road? Right. I guess with a Congressional Review Act, because the burden is put, on the prosecution to prove their case that the regulation is onerous, whereas this sort of flips it around. But is there a danger that an agency will break down these rules into discrete chunks so that they no longer hit the major rule threshold? Or is that invariably, an outcropping of this? Your thoughts here?
I suppose that's a possibility, and that would entertain litigation. New doctrines would need to be developed of are they artificially breaking down a rule? Certain things can't be done in incremental chunks, but maybe in some cases they would try to do an end run around this. But at any time you have new legislation that amends the APA or other statutes, you're going to have the litigation that tries to spell these out. You get ahead of that by kind of saying, well, you can't do an end run around it, but inevitably there are going to be clever lawyers who are going to try.
Speaking of inevitability, it was amazing to me during the 2016 election cycle to hear a presidential candidate utter the words regulatory budget. It's been a long time coming, but folks are finally starting to really take, and I mean, in the general mindset, are starting to take the impact of regulations seriously. Is it because we've just hit a massive threshold in terms of the interference on a daily basis, or has the free market and limited government side just gotten better at making the case to people? Why do you think we're in this moment now where we can really take the bull by the horns when it comes to regulatory costs?
It could be because there's very little political appetite for cutting the overall fiscal budget, the actual outlays, whether we're talking about entitlements or whether we're talking about earmarks and subsidies of various kinds. And it's easier to go after nameless, faceless bureaucrats. So maybe at least in this sense, the public choice economics, the incentives that we all face, are working towards us in our favor with respect to the regulatory state, if not quite with the debt and deficit.
Ilya, how do folks find out more about the good work that you're doing?
Yeah, so I'm at the Manhattan Institute. The website is manhattan.institute. There's no org, there's no com, anything like that. Manhattan.institute. You can find me there. I also have a Substack, a newsletter called Shapiro's Gavel, and I'm on Twitter or X at iShapiro.
At iShapiro, the books are Lawless, The Miseducation of America's Elites, and Supreme Disorder, both issues that play handily into this discussion of the REINS Act. Ilya Shapiro, thank you so much for joining us today.
Good to be with you, Andrew.
Our guest has been Ilya Shapiro. He is the Director of Constitutional Studies for the Manhattan Institute. Go and check him out. This has been yet another episode in our special series focus on the REINS Act from the lunch hour at the Federal Newswire. I'm Andrew Langer. Enjoy the rest of your lunch.